Montana's activities to commemorate or celebrate Constitution Day. For those who don't know, in 2005, Senator Robert Byrd of West Virginia attached an amendment to an appropriations bill. And that amendment required that every year on September 17th, the day the Constitution was ratified, federal employees should receive education and training about the Constitution. But more to the point, for the University of Montana, the rider also required that all schools receiving federal funds, from kindergarten through medical schools, must provide programming on the U.S. Constitution or lose their federal funding. So in an effort not to lose our federal funding, here we are. I have some reservations about the feds telling us what to teach and when, and I have more reservations about taking constitutional instruction from a senator who spent most of his youth in the Ku Klux Klan. I prefer to take my constitutional instruction from someone who doesn't wear sheets. Thank you very much. But whatever the provenance of the holiday, the American Constitution certainly is a document worth celebrating. The great British statesman William Gladstone described the American Constitution as, quote, the most wonderful work ever struck off at a given time by the brain and purpose of man. Our Constitution is more than 200 years old, making it the oldest written Constitution still in effect. It's difficult to read the Constitution today without being struck by the extent to which it's an 18th century document. And yet, for all of its 18th century characteristics, it remains functioning and relevant. It's been amended only infrequently, 27 times over 210 plus years, or 200 plus years. And remember, the first 10 amendments were adopted at the time of the Constitution, and 3 more were adopted to make real the result of the Civil War. So half of the amendments came at 2 different times. One reason for its longevity, I think, is that the Constitution itself is adaptable. It provides for its own amendment, although not easily. But more important, it's a general statement of principles. It's a document of less than 8,000 words. It's intended to be really no more than an outline, how we go about doing things. Had it been much more detailed, it could not have survived the decades, the stresses of 2 centuries, during which the United States evolved from 13 states huddled on the eastern coast to a nation that spanned a continent. So even if some of us might be a little uncomfortable about having the feds, or particularly Robert Byrd, tell us what and when to teach about the Constitution, it is worth contemplating. I'd like to take a moment at this point to thank Provost Perry Brown, who provided support, a budget, staff assistance, all of which were necessary in putting this together, and Claudine Sellier in the Provost office deserves special thanks. We've had, over the last 7 years, some pretty impressive speakers here for Constitution Day, some of the biggest names in constitutional history and constitutional theory. And tonight we have a very impressive addition to that list. A scholar who works on an important, timely, and a contentious topic. Phillip Munoz is the Tocqueville Associate Professor of Religion and Public Life in the Department of Political Science at the University of Notre Dame. Professor Munoz did his BA at Claremont McKenna College, his MA at Boston College, and his PhD at Claremont Graduate School. His work is focused on the theme of religious liberty and the Constitution. His first book, God and the Founders, Madison, Washington, and Jefferson, was an impressive study of the thought of those 3 important founders on the topic of church and state. One reviewer described it as a lucidly written volume, which I think it is. And it provides, at least to me, the most impressive part is the sort of analysis of the contrasting and sometimes conflicting views of church and state among those 3 important founders. Professor Munoz has published in a number of important venues: the Harvard Journal of Law and Public Policy, the American Political Science Review, Review of Politics, the Wall Street Journal, and the Claremont Review of Books, among others. As I said, I think he's a worthy and impressive addition to our list of speakers, and so please join me in welcoming Professor Munoz here tonight.
Can you hear me okay? No? Can you hear me okay in the back? Okay? All right. Not really? No. How's that? If I speak a little louder? It's okay? Okay. Good evening. It's good to be here. Thank you so much for coming out tonight. When I found out the time of the lecture, I was a little bit worried. I didn't go to many Thursday night lectures when I was an undergraduate. So thank you, especially to the undergraduates, for making time in your day. And it seems like there's a number of community members here. So thank you very much. It's really, as a guest, I very much feel like your guest. And I very much appreciate you taking the time out of your busy lives to hear what I have to say. This is my second time to Montana. I'm from Seattle, so I jumped at the opportunity to come out west. I love it out here. And what a beautiful city you have and a beautiful campus. I had a delightful tour of downtown by Professor Meyer. Thank you very much for the invitation and your kind words. And I don't know that I'm going to leave tomorrow. I really enjoyed my time and a delightful dinner with some students tonight and some faculty members. So this is, it really is a pleasure for me to be here. I'm going to ask for a bit of patience and indulgence from you tonight for a number of reasons. One, I'm on East Coast time, and I usually go to sleep about now. So I'm a little bit worried, too. I'm told these chairs are more comfortable than the other room, so I don't know if that's good or bad for both of us. I have a young son. My first child was born just a few weeks ago, and I haven't really slept in about a month. Really looking forward to tonight in the quiet hotel room. So I'm gonna do my best to be as lucid as I can tonight. I know religious liberty has been much in the news, and this talk is not geared to dive into contemporary events, but it's certainly something I would be happy to talk about. So if you have any questions about contemporary events, and maybe we can talk about how what I am going to talk about elucidates contemporary events, I certainly welcome questions beyond the lecture to what's going on about religious liberty today. Okay, let me begin. For over 60 years, lawyers, judges, and scholars have debated how the founders meant to separate church and state and protect religious freedom. From time to time, usually when a federal court makes a controversial decision, the debate about religious freedom moves from academia and the courts to our nation's airwaves. In 2002, for example, when the Ninth Circuit Court of Appeals in San Francisco found Under God in Pledge of Allegiance elementary school recitations unconstitutional, conservatives decried liberal judicial activism and how those liberal judges were betraying our nation's founding principles. And it is true the founding fathers usually do work for Fox News, but in church-state law, liberals too employ the founders. When a narrow court majority upheld a Ten Commandments monument on the grounds of the Texas State Capitol in 2005, it was the liberal dissenters on the Supreme Court that claimed the court conservatives were abandoning our founders' secular republic and trying to impose that is, the conservatives were trying to impose their preferred version of state-sponsored Christianity on the nation. Considering that the modern Supreme Court first cited Jefferson and Madison to guide Establishment Clause jurisprudence in 1947, one might have thought that by now we would come to some agreement about how the founders intended to separate church and state. But 3 generations of scholarship, 3 generations of court decisions, 3 generations of debate have left scholars, judges, and the American public more divided now than ever before about our founding history. What I want to try to do this evening in my time with you is to explain why this historical debate exists and persists. And I want to try to explain, at least from my point of view, who gets what right. To do this, I'm going to do 3 things. I'm going to start with the liberal and conservative stories about the founders on church and state. And then I'll try to explain as best as I can, and according to my interpretation, what the founders actually thought by a careful study of their own words. I'm going to focus on the three most important founders, Jefferson, Madison, and Washington. I mean, you could argue that, what about John Adams? Maybe would be a fourth founder we would consider, but I think Adams really is very similar to Washington, and I think Washington stands for the school of thought that Adams. And I don't think, there are other founders certainly worth our study, but it's pretty clear to me that Jefferson, Madison, and Washington are the three most important founders on this subject. And then finally, I'll conclude with a few thoughts on how we might more thoughtfully and maybe more accurately approach the founders' competing wisdoms. Okay, so let me begin with the liberal story. The liberal story about the Founding Fathers goes something like this, an oversimplified version. In the beginning, there was persecution, and it was bad. Wars of religion devastated Europe. Catholics persecuted Protestants, Protestants persecuted Catholics, Protestants persecuted other Protestants, and everybody persecuted the Jews. Settlers came to America to escape religious persecution, but before long, religious dissenters were persecuted here too. The nasty habits of the old world infected the new, because religion in the liberal story is intimately tied to, because religion was intimately tied to politics, and religion in the liberal story by its nature breeds unreasonable and hence unresolvable political conflicts. The cycle of theological disputes leading to political oppression persisted until the founders built the first secular republic. The founders separated religion from politics, which secured freedom by preventing sectarian and theological disagreements from contaminating political life. The key to the founders' solution in this liberal story is the privatization of religion and the elimination or minimization of religion in the public square. This privatization effort was furthered by the Supreme Court in the 20th century. Prayer and Bible reading were eliminated from the public schools. Parochial schools, mainly Catholic schools, were prohibited from receiving most public funds. And many religious symbols, though not all, were removed from the public square. All this was done, again, in the liberal story according to the spirit of the founders. To the extent that religion hasn't been completely privatized, maybe most notoriously from the liberal point of view by the 2001 court decision that allowed publicly funded vouchers to extend to religious schools, including Catholic schools. Liberals understand this to be a deviation from the course of history the founders intended to place us on. The judicial authors of this liberal story include Justice Hugo Black, Justices Brennan and Marshall, and more recently Justices Souter, Stevens, to some extent Justice O'Connor, and today on the court, Justice Ginsburg. Okay, the conservative story. The conservative account of the founders has been written largely in response to this liberal story. For the most part, conservatives agree that the founders meant to separate church from state, but they deny that this means religion must be separated from politics. Separation of church and state for conservatives means that no one particular religion ought to be favored by the government. Conservatives tend to believe that the state can favor religion generally, just so long as it does not single out one religion, as long as it remains neutral towards religion and among religion, though it does not need to remain neutral towards religion in general. Conservative academics in particular, tend to be somewhat suspicious of the founders' political theory, perhaps because they suspect liberals might be right, but they admire the founders' practices. Conservatives relish documenting the many and various ways the founders supported religion. Declaration of Independence, conservatives point out, has 4 references to God. The first Congress enacted legislation appointing publicly funded legislative chaplains, and it did so the very same week it passed the First Amendment. 3 of the first 4 presidents issued official days of prayer and thanksgiving, and the Supreme Court under John Marshall started its sessions with a prayer. Actions, conservatives say, speak louder than words, and the founders' actions reveal a long history of government support of religion. The authors of the conservative story include the late Chief Justice Rehnquist, Justice on the court today, Justice Scalia and Thomas, and former federal judge and now Stanford law professor Michael McConnell. Okay, so who's right? I mean, and these are these are general sweeping stories about the conservatives and liberals. Obviously, lots of nuances within each camp. But these general stories, who's right, or maybe to be just a little bit more subtle, who's more accurate? When I started my research, I actually thought it was probably the conservatives that historically had the better case. But it turns out the historical record, at least in my view, is more complicated and more interesting than either the liberal story or the conservative story would let us know. In my interpretation, I believe the leading founders disagreed about the proper separation of church and state. As I'll try to demonstrate tonight, Jefferson, Madison, and Washington, again, the three leading spokesmen from the founding generation, offered different approaches to the proper relationship between religion and politics. Both the liberal and conservative stories contain some truth, but both stories miss as much as they get right. And both stories offer an incomplete and therefore a misleading account of God and the founders. Okay, one caveat here. And what I'm about to do, I'm going to just assert some points without really documenting them. And I want to say that up front. I mean, these stories are complicated, these individuals are complicated, and so I want to invite you, if I go over something too quickly or you want some more clarification, or if I say something that just doesn't seem persuasive, please don't hesitate to ask. Okay, let me start with Jefferson. I start with Jefferson because he's the most interesting founder and also the most difficult founder to understand on these matters. And he's interesting and difficult for the same reasons. Jefferson did not practice what he preached. He said one thing about religious freedom, but he often did something else. When reflecting on our third president, we have to ask, is this Jefferson the rhetorician, the statesman-like rhetorician, or is it Jefferson the anti-clerical, hard-headed political actor? What Jefferson said publicly is encapsulated in his famous statute for religious freedom. This was a Virginia bill that was adopted by his home state in 1786. Jefferson actually drafted the statute in the late 1770s. Let me just pause here, a footnote. So Virginia is so interesting for any number of reasons, but Virginia had an established church. Colonial Virginia had an established church, and of course, who's the head? And it was the Anglican church that was established. So who's the head of the Anglican church? The King of England, who's also the target of our Declaration of Independence, right? So obviously you're going to have to change things, right? I mean, just as a practical matter, you can't keep the old Anglican establishment because the king's a tyrant, according to the Declaration of Independence, right? So something had to happen in Virginia, had to be changed in Virginia. It's one of the reasons why Virginia gets so much attention. It's why Jefferson drafted this statute for religious freedom. He first started it in 1777. Okay, so in the statute, Jefferson recognizes 5 overlapping rights. And this is my summary. It's not a quote from Jefferson's bill. Okay, so here's the problem. Jefferson did not follow these natural right precepts in his own political practice. Right? And what I try to do in my book is go through all the different actions Jefferson actually took about church and state. Here, tonight, let me just summarize what I think to be the most revealing. Although Jefferson declared that no individual civil capacity should be affected by religion, that's point 5 I have here, Jefferson repeatedly sought to impose special disabilities on members of the clergy. In 1783, for example, he drafted a proposed constitution for the state of Virginia, a constitution that wasn't adopted, but he drafted a proposed constitution. In his proposal, Jefferson excluded ministers of the gospel from eligibility for election to the General Assembly, right, an exclusion of ministers from holding office. When he was asked about this exclusion, Jefferson responded in a surprisingly candid letter. He says, "The clergy are excluded because if admitted into the legislature at all, the probability is that they would form its majority." Jefferson said clergy had to be excluded from the ballot because if they weren't, they'd win election. And clergy couldn't be allowed to hold office because clerical power, he said, quoting here, has filled the history of 10 or 12 centuries with too many atrocities not to merit a proscription for meddling with government. Jefferson failed to get this exclusion into the Virginia state constitution, But his effort to restrict clergymen's rights, civil rights, and to reduce clergymen's societal influence would resurface time and time again. In 1817, so towards the beginning of his political career, but also towards the end of his political career, in 1817, in a bill establishing elementary education in the state of Virginia, Jefferson, of course, is the father of public education in Virginia, and in many ways, the father of public education in the nation. In 1817, Jefferson sought a legal prohibition against clergymen from serving on what was called the Board of Visitors, I think local school boards. He did not want clergy directing or influencing Virginia's public schools. The legal exclusion of clergymen from political office was just one aspect of his larger church-state reformation project. Jefferson sought to transform Americans' religious opinions through public education. He insisted that young school children not read the Bible in Virginia's public schools. Young minds, he said, and again I'm quoting, are not sufficiently mature for religious inquiries. Jefferson recommended instead that children be taught morality with, again I'm quoting, the most useful facts from Grecian, Roman, European, and American history. He wanted Scripture banned from the curriculum so children's minds and imaginations would be kept free of miraculous truths and revealed dogmas. Superstitions, he thought, that would inhibit the critical analysis of religion he wanted his more advanced students to undertake. And these advanced students would undertake this examination at the University of Virginia, which he also founded. Jefferson designed the curriculum of UVA to minimize clerical influence. Instead of a professor of divinity, which was standard at the time, Jefferson proposed a professor of ethics. This would allow the university to teach morality without sectarianism, and most importantly, without a member of the clergy on the faculty. When Jefferson made his first round of faculty appointments, he caused a public stir by selecting a number of professors known for their heterodox religious opinions. Evangelical Christians' distrust of Jefferson ran so deep that his friends in the legislature said he needed to do everything possible to arrest the suspicion that he was trying to establish Unitarianism at UVA. I don't know if you've been to UVA, you know the great lawn and the pavilions. I mean, Jefferson was a magnificent architect. And there's 10 pavilions. There's 10 pavilions because there's to be 10 faculty members. And a faculty member would live, they'd teach their classes downstairs and live upstairs. I mean, faculty, could you imagine that? Right? And so Jefferson handpicked the first 10 faculty members. And his picks, as I suggested, were wildly controversial. Almost so that Jefferson almost lost funding for the university. Okay, so why did Jefferson want to keep Bibles away from school children and clergymen away from college students? And why was he willing to suspend the civil rights of clergymen, even in contradiction to his own stated principles of religious freedom? You know, everything I've said so far is pretty much just facts. Here's where the interpretation starts. I believe what explains Jefferson's actions is that he held a progressive or developmental view of religious freedom. Jefferson did not believe we could simply ascertain fundamental rights and then straightforwardly apply them. He thought religious freedom itself had to be established, and that required taking into account what we might call today the social context or the distribution of societal power of the time. Jefferson was particularly keen to subjugate clerical influence in education because he thought it stood, that is, clerical influence stood, as a barrier to progress in human thinking. He embraced the basic Enlightenment critique of revealed religion and religious authority. He thought church authorities invented theological doctrines to disarm human reason, and then they used those dogmas and the power of the state to suppress the ideas and individuals that might threaten clerical power and influence. If men were freed from the artificial constraints that the clergy had imposed on them, Jefferson believed that they would be guided by science and reason alone. I mean, this sort of sounds familiar in the modern academy. Jefferson was a true progressive insofar as he believed that to secure progress, one had to remove what he often would call monkish ignorance. The monkish ignorance that arrested progress's development. And the opinions and institutions that Jefferson thought most responsible for this monkish ignorance were those advanced by ecclesiastical religions and their authorities. To establish religious freedom, then, required the subjugation and the influence of religious clergy in American society. The one sentence that encapsulates Jefferson's approach to church and state is not his famous wall of separation metaphor found in his letter to the Danbury Baptist Association, but rather this candid statement, something Jefferson didn't release publicly, but what you find in his private letters. History, he said, history, I believe, furnishes no example of a priest-ridden people maintaining a free civil government. So although Jefferson articulated natural rights principles in his famous Virginia statute, his approach to religious liberty might be more accurately characterized as a politics that sought to aid the march of progress by transforming and thereby overcoming traditional religion, thereby emancipating individuals to develop their minds and spirits according to the dictates of reason alone. For Jefferson, religious freedom primarily meant freedom from the dogmas, influence, and priests of Orthodox Christianity. It's no coincidence that today's liberal story of religious freedom holds Jefferson as its God. When the Supreme Court removed prayer and Bible reading from the public schools, eliminated religious symbols from the public square, and prohibited religious organizations from receiving public funds, at least in some circumstances, it resumed the liberal project that Jefferson himself began. Okay, let me now turn to James Madison. No founder has been more misrepresented and misused, maybe you might say abused, than James Madison on church and state. In fact, that's particularly ironic given that Madison's church-state views are relatively simple and straightforward. Madison is portrayed as the constitutional foreman who built Jefferson's strict wall of separation. They were great allies on church-state matters. This interpretation was initiated in 1947 by Justice Wiley Rutledge in the famous Everson case. It was championed over and over again more recently by Justice Souter. Both justices, both Rutledge and Souter, and to some extent Justice Kagan now, claimed that Madison was unrelentingly absolute in opposing state support of religion. This view is not exactly wrong, but it's woefully incomplete. The scholars and judges who have appealed to Madison have not really understood the social compact theory that informed his thought. And in doing so, they have failed to understand Madison's principle of religious freedom. Madison's, let me pause here for another footnote. So one of the reasons, especially you law students, need to take history classes and political theory classes is that to understand Madison's legal principles, you have to understand the political theory and the historical context in which he wrote. And if you don't understand these things, you're not going to understand the words he used and the underlying ideas behind them. Right? This is why I teach at the law school at Notre Dame, and I'm constantly trying to convince our law faculty that if you want to study originalism, for example, you have to study the political theory of originalism. That means you actually need political scientists or historians, not just law professors. Law professors don't find that argument very persuasive. Doesn't mean it's not true. Okay, Madison's most authoritative statement about religious freedom is his Memorial and Remonstrance, a 1785 document that he circulated in opposition to Patrick Henry's bill to subsidize religious clergy in the state of Virginia. Okay, let me pause again here. So I mentioned that Virginia had to overthrow its church-state arrangements because the Anglican Church was established. So we have the Revolution, it's successful. In the early 1780s, 1784 to be precise, the question is, well, what are we going to do about religion in the state of Virginia? Patrick Henry, one of the towering figures of the time, proposed a property tax, basically a religion tax, a property tax where the taxpayer would specify to which minister he wanted or she wanted the tax to go to. Right? So a general assessment, but it was taxpayer directed, religious state funding of religion, but taxpayer directed. You fund whatever your own minister. And if you didn't have a minister, you just the taxes go to the state to support education. So Madison wrote his Memorial and Remonstrance against Henry's bill. The reason we study Madison's Memorial and Remonstrance is because he gives the argument in it for religious freedom, for his principled understanding of religious freedom. And that comes in Article 1. It's the most important and the most philosophical part of the argument. And in Article 1, and you have excerpts from Article 1, Madison defends the natural right in the philosophical argument for the natural right to religious freedom. Now, the argument is not altogether simple, but I'm going to try to simplify it somewhat. Madison derives the right to religious freedom from the nature of religion itself. Religion, he says, involves opinions about God and our religious obligations. Our religious obligations, he continues, can only be fulfilled according to conviction and conscience. To use modern terminology, I think what Madison means is that our religious practices must be sincere or authentic to be truly religious. This means, he says, that we cannot give the state authority over religion because our opinions, including or especially our religious opinions, follow from evidence alone. Right? We believe what we believe. Right? Our opinions follow from what we're taught, what we see, what we understand, what we apprehend. Opinions cannot be coerced. Right? You can tell someone to believe that that wall is black. But if you know what red is, you know that it's red. And even if I try to punish you or threaten you with physical violence to believe that wall is black, you can't actually believe the wall is black because you see that it's red and you know what red is and you know what black is and you know that that is not black. Coercion doesn't work on opinions. Okay. This means that we cannot give the state over religion because religion primarily is a matter of opinion. Since religious opinions cannot be coerced, the force of law cannot actually lead men to saving religious belief. Moreover, it would never be in our interest to cede authority over religion to the state because religious practice must be sincere to be salutary. So just as no rational man would ever sacrifice his or her eternal soul for the temporary good of their bodies, individuals who have been created to worship God according to conscience should never make their religious duties part of the social compact. Right? The nature of religion, then, and religious obligations, according to Madison, means that religious liberty is a natural right, and it's a special kind of natural right. He says it's an unalienable right. Right? And for Madison, this has a precise meaning. He says, we maintain, therefore, in matters of religion, no man's right is abridged by the institution of civil society, in that religion is wholly exempt from its, that is, from society's, cognizance. He says, because religion is an unalienable right, it cannot be a legitimate part of the state's jurisdiction. Used in a legal sense, cognizance means the action of taking judicial notice of. More generally, it means jurisdiction. It can mean knowledge, perception, or the state of being aware of. So a state non-cognizant of religion, it lacks jurisdiction over religion. Or I could explain this a different way, maybe a more straightforward way. If I said a colorblind constitution, you may or may not agree with that, but you would know what I meant. What Madison was advocating was a religion-blind constitution. In a religion-blind republic, lawmakers would not take authoritative notice of or perceive the religion or religious affiliation of citizens. Lawmakers would not make distinctions between religious and non-religious citizens. The law would neither use religion as a ground of preference nor as a ground of penalty. Madison's teaching on the proper relationship between church and state is the state non-cognizance of religion or state blindness towards religion. And with only a handful of exceptions, Madison followed this principle in his political life. Let me give you a few examples from Madison's actions and how he applied his principle of non-cognizance. Okay, I mentioned that Madison wrote the Memorial and Remonstrance in response to Patrick Henry's property tax to fund religious ministers. Madison thought the legislation was improper because it was not within the state's jurisdiction to impose special taxes for religion alone. And for the same reason, he opposed legislative and military chaplains, and also official religious proclamations by state officials, including the president. A state non-cognizant of religion could not tax citizens for its support or in any official manner employ religious clergy or even request citizens to pray. Right? Madison goes so far as he says, even for Navy crewmen at sea, right? I mean, they can't go to church, right? They're at sea. It's wrong for the state to supply them, to pay, to employ military chaplains, right? I mean, he's in this distinctive minority on this point. But he said that's the right derivation of the principle. Okay, it's Madison's position, these actions that have led scholars and more than a few Supreme Court justices to identify Madison as a strict separationist in church-state matters. But what this interpretation leaves out is that Madison also opposed state policies that singled out religion for disabilities. Madison, to take just one example, strenuously opposed religious tests for political office. Now, at the time of the founding, these tests were not uncommon. And Jefferson, as I've already noted, proposed to exclude ministers of the gospel from the Virginia state legislature. When Madison learned of Jefferson's proposal, he wrote to his friend and criticized it. I mean, and this is, you have to understand the context. Jefferson is a senior statesman. Madison is his sort of mentee, right? So he's looking up to one of the most distinguished men in America. And he wrote to him, and he said, "Your prohibition violates a fundamental principle of liberty." In Madison's original submission for what became the First Amendment, Madison proposed the rule that, and I'm quoting here, "The civil rights of none shall be abridged on account of religious belief or worship." So it is true that Madison stood against state action that directly favored religion, like Patrick Henry's property tax. But Madison also stood against state action that excluded or discriminated against religion, or discriminated against citizens on account of their religion. A Madison approach to the Establishment Clause, accordingly, would not support the jurisprudence that voted, the liberal jurisprudence that voted to prohibit private religious schools from receiving state-funded vouchers, or attempts to exclude religious groups from using public school buildings. Or there's a case in California law school where the religious group was excluded. These dogmas of strict separationism unfairly discriminate against religion and violate the principle of religious freedom from a Madisonian point of view. Under a Madison approach, religious schools should be treated just no better, but no worse than other schools. So on church-state matters, Madison corresponds to neither the liberal nor the conservative story. Okay, a little bit more quickly now, let me turn to George Washington. When you review Washington's politics, you can't note but how different they are from Madison and Jefferson's. George Washington consistently sought to use governmental authority to encourage religion and to foster the religious character of the American people. Washington was originally not opposed to Patrick Henry's General Assessment Bill. He later opposed it because it was causing so much controversy, but at first he said he thought it was a good idea. Washington thought that it was permissible to tax citizens to support their own religion. Right, this is a quote from his support of Patrick Henry's bill. Washington firmly endorsed military chaplains. Right, this is maybe the clearest difference from Madison. Washington said that chaplains helped to improve discipline, raised morale, they helped to check vice, and they fortified the courage and bravery of his soldiers. Washington also said chaplains helped secure obedience and respect for those in command. And as president, George Washington inaugurated the tradition of declaring official days of prayer and thanksgiving. Another point of difference from Madison. Now, I said that Madison did make a few exceptions in his practice from his rule. One of Madison's exceptions was, as president, he issued 4 official proclamations of prayer and thanksgiving. But after Madison left the presidency, Madison himself said his actions were unconstitutional. He said Congress made him do it. Washington took no such view of religious proclamations. Washington's 2 religious proclamations both begin by affirming the duty of all nations and the American people to acknowledge Almighty God. So the use of taxes to support religion the use of taxes to employ military chaplains, presidential religious proclamations. These all exemplify the distance between Washington on the one hand and Madison and Jefferson on the other, regarding the proper disposition of religion towards, proper disposition of government toward religion. Washington did not think the state should be blind or non-cognizant towards religion. He certainly agreed with Madison that religious worship was a natural right and that the purpose of government was to secure rights, but he did not translate those general principles of government into Madison's specific limitations on the legitimate powers of government. In fact, Washington's most definitive statement on religion pertains to the propriety of government support of religion. In his farewell address, we call it the farewell address. Washington did not actually, it's not a speech, he wrote it and it was published in the newspapers. In his farewell address, Washington wrote, "Of all dispositions and habits which lead to political prosperity, religion and morality are indispensable supports." He thought religion indispensable because, he explains a few lines later, it's substantially true that virtue or morality is a necessary spring of popular government. And virtue and morality are needed for public happiness because virtue and morality are what prompt citizens to act in a decent, truthful, and law-abiding manner. Virtuous citizens can govern themselves. Virtuous citizens respect the rights of others. They thereby reduce the need for security through the coercive force of law. Virtue and morality are indispensable, in short, because they make limited government possible. And religion, Washington continues, is indispensable for the cultivation of virtue and morality. Let us with caution indulge the supposition, he warns, that morality can be maintained without religion. Washington concedes that a few may be good on account of their refined education, but he suggests that most men, most of the time, require religion to fortify their character. Washington therefore endorsed the use of religion to nurture patriotic and moral citizens, something Madison thought was unnecessary and illegitimate. But from a Washingtonian perspective, Madison's religion blindness principle ignored the reality that Republican government, small r Republican government, needs religion. To separate religious morality from state support would, in Washington's view, imprudently destabilize the very foundation of the moral character upon which Republican government depends. So when conservatives say that the founders endorsed religion in general, and maybe even Christianity in particular, I think they have in mind founders like George Washington. Like Justices Rehnquist and Scalia and many cultural conservatives today, George Washington thought that the state could and should favor religion because religion helped to cultivate the citizen virtues necessary for liberal democracy to flourish. Okay, my argument, as you no doubt can understand by now, is that the leading founders disagreed about the proper separation of church and state. They all articulate the idea that religious liberty is a right and that government, the role of government is to protect rights. But they disagreed about what that meant for, in terms of politics and constitutional politics. In today's terms, Jefferson would be most similar to the progressive liberals who seek to use state power to suppress the influence of religious orthodoxy and religious authority. Washington would be most similar to conservatives who would allow the state to support religion, especially for political purposes, to nurture character. Think of education. Madison is somewhere in between, or maybe he's outside of this dichotomy. Maybe we could say, and since I'm in Montana, maybe you could say he's most like today's libertarians, who would limit the reach of state power, governmental power, but by not allowing the government to favor or disfavor religion as such. Okay, so what does all this history teach us about the founders and church-state jurisprudence? If I was a historian, I could just end here, right? But I'm not, so I'll continue. So let me conclude with 3 lessons I think we can draw from this history. From the perspective of originalism, the judicial philosophy of originalism, strictly speaking, it's the public meaning of the Constitution's text that's binding. But because the meaning of the First Amendment religion clauses is not clear, both justices and scholars have tended to turn to the founders as a substitute. You don't understand the text, look to the authors of the text. The leading founders' disagreement, however, means that there's no single church-state position that could or should claim exclusive authority of America's founding history. So the first lesson we should draw is that no one founder should be assumed to reflect the original meaning of the religion clauses. And this means that jurisprudential appeals to any one founder should be treated with a large dose of circumspection, especially if the appeal claims to represent the view of the founders. It's easy to pick and choose from the founders to support different church-state jurisprudential results. If you want to keep prayer out of public schools, you refer maybe to Jefferson or to Madison. But if you want to keep prayer in public schools, then you quote Washington. I get these calls from time to time from lawyers looking for quotations to support their arguments. I mean, it's really quite easy to do. But to offer a single quotation or just a few examples from one founder, and then to use those examples to imply that the entire founding generation stood for a particular understanding of religious liberty, is bad history and is bad jurisprudence. Because the leading founders disagreed, simply having a founder on one side is not an adequate legal argument. Okay, some interpret this to mean that the founders shouldn't be considered at all, that they're no longer pertinent or relevant to contemporary church-state concerns. I disagree with that interpretation, and I hope you won't take that interpretation from my talk. I mean, that's a bad interpretation for me because no one would buy my book. But how the founders disagreed makes them worthy of our consideration in a legal and just to think about these matters more generally. Because the founders disagreed, they made arguments. They made arguments to defend their competing positions. And to be honest, those arguments are far more thoughtful, nuanced, philosophical, and interesting than the arguments our legal scholars and our justices make today. The founders employed philosophical reasoning and prudential considerations in their arguments, and that reasoning and those considerations are as applicable today as they were 200 years ago. So the second lesson I would have us draw is that understanding the founders' differences, and most importantly, the reasons why they disagreed, can help us think through the proper relationship between church and state today. And disregarding the founders because they're old or because they disagreed, because they wrote in a different age, unnecessarily overlooks the thoughtfulness of some of America's greatest political thinkers. So even if we cannot or should not turn to the founders in a deferential manner, we can certainly still learn from their ideas and especially their arguments. So if we do decide to adopt a view from the founding, which founder offers the best approach? Okay, so my primary objective tonight has been to explain, at least the best I can, my understanding of the leading three founders to you, not necessarily to evaluate them. But if we want history to be useful, we need to make evaluations and judgments. I think something could be said for all three positions. But, and again, this is me speaking as a citizen, less than a scholar. I think Madison's approach offers the most promise, in part because it avoids the fundamental weaknesses of the other two approach. So this is the third lesson that I would have us draw. Okay, let me try to explain this conclusion. The most dramatic problem with Jefferson's position is that, to be blunt, it counsels discrimination against religion, or at least certain types of religion. Jefferson did not aim to be neutral toward religion. He aimed to subjugate Orthodox Christianity and to subvert clerical influence in American society. If one does not endorse his project to transform America's religious opinions, and if one does not share his anti-clerical hostility toward religion, it's hard to find favor with Jefferson's approach to church and state. Let me just add as a parenthetical thought here that many of Justice Black was referenced as a member of the KKK. How deep that membership was, one might debate. But clearly, Black's church-state views, the whole wall of separation idea that was born in the 1947, and Justice Rutledge, who was a real force, I mean, that was all about anti-Catholicism, right? There's a recent book that's been published that dives into Rutledge's papers. And what Rutledge says about this case, this famous case, still a sitting precedent, is we got to keep the money away from the Catholics, right? It's all anti-Catholicism. Okay, many conservatives find Washington's approach to be the most attractive. They find it attractive because it allows the state to support religion and to promote the civic purposes that religion can serve. And thus those who find this approach appealing are most likely to share Washington's estimation of the beneficial civic qualities of religion. I think one can say much actually in favor of this view, but let me suggest a few drawbacks. Washingtonianism, if I can use that term, views religion in a politically utilitarian manner. Take prayer in public schools. A Washingtonian approach might defend prayer in public schools the same way that Washington defended military chaplains. Prayer might be said to improve discipline, check misbehavior, help secure respect for teachers. Yet understanding prayer in this way fundamentally misunderstands why religious people pray, at least from a religious point of view. It reduces religious activity to a means by which to achieve political ends. At minimum, I think this should make religious citizens, in fact all citizens, uncomfortable. Moreover, if communal prayers are going to be said in the public school, who's going to write them? I mean, my mother was a public school teacher, and my sister is a public school counselor, but it's not clear to me that we want teachers' unions writing prayers for our children. Again, I'm not trying to disparage public school teachers or public administrators, but to entrust, I mean, from a religious point of view, to entrust something as important as prayer to them may not be the best idea. To generalize, the Washingtonian approach, in my view, gives the state too much authority over religion. So in instances when the interests of the state are different from what is good or true to religion, that authority can be very harmful to religion and religious freedom. Now, one hesitates to disagree with George Washington, especially at a Constitution Day lecture, especially on a matter of prudence. But his position in this area, I think, could do more harm to religion and religious freedom than good, even if he's right about the beneficial qualities of religion to the state. Okay, Madison's approach, as I suggested, at least in my view, avoids these problems because it denies the state direct authority over religion. By requiring the state to remain blind to religion or non-cognizant toward religion, it also avoids the hostility towards religion that Jeffersonianism would impose. Another strength of Madison's approach is that it embraces the old-fashioned idea of equality of all before the law. A religion-blind government could neither privilege religion nor penalize religion or religious citizens as such. Religious citizens would be treated the same as non-religious citizens. Right? That's what we used to mean by equality. A further strength of Madisonianism is its transparency and its workability. In most cases, the principle of non-cognizance can be applied consistently, straightforwardly, with a minimum amount of discretion. Judges would simply ask, does the state action in question take cognizance of religion? In many instances, the requirements of a religion-blind constitution are sufficiently knowable that church-state issues could be resolved without recourse to lawyers, something that law professors tend not to like. Take participation by religious groups in state-funded programs. Non-cognizance would prevent the state from either including or excluding participation on the basis of religion. Religious groups could participate in government-funded programs as long as they qualified for doing so on the basis of some non-religious criterion. Any state-funded program that limited participation to religious groups or, more commonly, excluded religious groups on account of their religious affiliation would be impermissible. And the simplicity of the principle may be its greatest asset. Lawyers don't like that either. Okay, let me draw to a close here. Tried to explain the church-state thought of our leading founding fathers. I've suggested that liberals and conservatives continue to appeal to the founders, in part because both sides can find something in those founding positions to support their own positions. But I hope I've made clear by now that both sides embrace a partial and therefore a misleading understanding of our history. By clarifying how Jefferson and Madison and Washington sought to separate church and state, by clarifying their differences and also their arguments, I hope that we might be provoked to think more clearly and hopefully more deeply about how we can best protect religious freedom today. For reasons I too briefly sketched, I would conclude that Madison offers the most promise. But that's a conclusion we should certainly talk about, and I certainly would appreciate any questions you have. Thank you very much. Shall I just call for questions? Okay, I'm going to do something I do at Notre Dame, which is invite undergraduates to ask the first questions. And I know undergraduates are both young and old nowadays, but please. And tell me your name, sorry.
My name is Munoz.
Okay.
So with your Madison point of view, this is sort of dealing with the Obamacare and the Catholic charities and all that. It seems to me that I can't really. I would understand. I'm trying to understand what would a Madison point of view be on that? Because on the one hand, you make Catholic charities give out, birth control and all that. But on the other hand, if everybody else is doing it, wouldn't that be a special privilege for them as well? Like they don't have to.
Yeah, that's a nice question. First of all, it's not easy to answer because it's not easy to know what's in the Patient Protection and Affordable Care Act, right? It's pretty big.
Yeah.
But from what I know about it, and I'm certainly not an expert on it, everyone would violate a Madisonian perspective in this issue. Obamacare would be unconstitutional, especially the HHS mandate. This is the contraception mandate. Everyone know what I'm talking about? Should I step back and explain this a little bit? Okay, let me just step back for a second. The Secretary of Health and Human Services, Kathleen Sebelius, implemented a regulation as a part of Obamacare that forces employers of more than 50 with more than 50 employees to provide certain reproductive services to their employees. Employers must provide it to their employees. Right? Contraception is the main thing, but also some forms of contraception that some people say are abortifacients. And I don't know the details about that, but under commonly accepted definitions, I think they are abortifacients. Okay. So employers like my employer, Notre Dame, or under Obamacare, has to provide its employees with contraception. Okay. There's been a lawsuit filed by Notre Dame and many others saying that this is unconstitutional, and Notre Dame needs an exemption from the legislation. Okay. Madison would say both sides are violating a proper understanding of religious liberty. First of all, Obamacare violates a proper understanding of religious liberty because in the legislation itself, all sorts of exemptions are given to certain religious groups, by name actually. The Amish, certain types of Amish get an exemption from the litigation, from the legislation. And Madison would say you can't do that. You can't single out certain groups and give them an exemption from the law because of their religious affiliation. He would also say to the University of Notre Dame, no, religious freedom is not getting a special privilege on account of your religion, right? Because to do that, to get a special privilege, that means the state, and it's the state official that will grant the privilege, implicitly has to make the judgment, you are religious or you're not a religious. Right? To be exemption eligible, to get the exemption, you have to be religious. That means a judge or a bureaucrat has to say, yes, you are authentically religious. Think of a private company. Okay, everyone knows Notre Dame is religious. What if you own a company? Right? Say a Catholic businesswoman. She owns a company and she says, look, my company, the reason I'm operating this company, whatever it is for religious purposes. And Madison would say, look, if you're filing for an exemption, you're saying to a judge or a government official, you need to judge whether I'm sufficiently religious to get an exemption. The whole purpose of religious freedom, in Madison's view, is to keep state officials from making that judgment. Right? So the legislation itself would violate religious liberty, and the religious liberty claims invert the principle of religious liberty from a Madisonian point of view. Now let me try to back up. There's one, so why would Madison say you can't grant to religious companies an exemption, right? I mean, for reasons I don't really understand, these Amish groups were given this exemption in the law. Well, why were the Amish groups given the exemption in the law? I mean, I don't really know. I mean, maybe they have really good lobbyists or something. But I'm going to hazard a guess here. Amish groups were given an exemption because someone from the Amish community explained to the Obama administration, if you implement this law and apply it against us, it will be extraordinarily oppressive to us. It will destroy our way of life. And someone in the Obama administration probably read their argument and said, okay, we don't want to do that, therefore we'll give you an exemption. What Madison would say is, when small groups or even big groups like the Catholic Church feel oppressed by legislation, and if they need an exemption for legislation to not be oppressive, one needs to reconsider the legislation itself. Right? Oppression of small groups is like a fever. I'm making this up, and it's not what Madison said, but right? It's an indication that the legislation itself may not be wise. Let me put it another way. Exemptions buy off religious opposition, or any opposition, to laws which themselves may not be wise. Right? Right? If a law really is a good law, apply it to everyone, Madison would say. If you can't apply it to everyone, maybe you shouldn't pass it and apply it to anyone. Right? If you cannot apply a law to everyone fairly, maybe that law should not be passed. And the textual evidence for that claim, by the way, is Federalist 57. Right? He says, in Federalist 57, Madison says, the surest safeguard to liberty is that those who make the law will be subject to the law. Right? You start excluding people from being subject to the law, you start getting laws that oppress liberty. Again, from a Madison point of view. Okay. Please, sir.
One sees a frequent quotation of Washington that says, in no way can you say that the United States was founded as a Christian nation. Was that an accurate quote?
Well, I don't know the quotation you're referring to. So I'm not sure. Let me give you an example of which I think maybe might explain Washington's position. So after Washington was elected president, all these groups wrote to him. All these religious groups wrote to him. And when Washington wrote back, and it's a wonderful study to read these letters. You know, Washington's usually thought as not our most philosophical of the founders, you know, Jefferson and Madison. But, you know, Washington's collected volumes are like 35 volumes. I mean, he wrote a lot, right? And he might not have had a formal education like Madison and Jefferson did, but he was a profound thinker in his own right. So all these groups wrote to Washington. And in his responses, we have some of Washington's most famous letters. His letter to the Hebrew congregation at Newport, letter to the Catholics. The letter I like the most is the letter he wrote to the Presbyterians. So the Presbyterians wrote to Washington, and they said many things, but you know, we are basically, paraphrasing here, we're so happy you're president. We know the government under your administration will not threaten religious liberty and will be a great Christian example of showing the greatness of Christ, or something like that. The Presbyterians invoke Jesus Christ in their letter. So Washington writes back to them. And what you see in Washington's letters is that his letters to the religious groups mirror their letters to them. Right? So they say something, Washington says basically the same thing back to them. So Washington's letter to the Presbyterians mirrors exactly what the Presbyterians say to him, except to the point where the Presbyterian letter becomes sectarian. When the Presbyterians talk about the example of the government being a Christian example and an example of doing glory to Christ, Washington says our government will do glory to the principle of religious freedom. Right. I think that says more about Washington than anything. It's not that the government is a Christian nation or is not a Christian nation. Certainly, I'm sure he thought it was compatible with Christianity. But what the American government is the most is a government dedicated to freedom. Right? It says the principles of civil and religious freedom, Washington says, are what brought me into the field of battle. Let's go way in the back, please.
Yes, you may be familiar with this book. It's entitled The Impossibility of Religious Freedom, and it's by a woman named, a scholar named Winifred Sullivan. I'm not sure what her field is. She makes this very, very interesting, provocative suggestion that the establishment clause of the First Amendment, which forbids Congress from regarding the establishment of religion, actually undercuts any kind of adjudication, any kind of court's jurisdiction over the free exercise clause, simply because all of the things you've been talking about. Because what has happened over the years is that courts are all of a sudden, they are, they're asked to adjudicate religion. What is a religion? What is a church? Who is a clergyman? And what specifically is a religious exercise before you can get to the point of should this exercise be protected? Are you familiar with that?
No, I'm not familiar with the book, but I already don't like it, so that's good enough. I don't think that's right. Right? I mean, I'm not saying it's easy, but I don't think that's right. Because in part that would mean that the authors of the First Amendment were, dim-witted, which I also don't think is right. Right? It means that there's no such thing as a natural right to religious freedom. So let me just take, it's not easy to define what a religion is, and it's not easy to figure out what's a religious practice. Right? In fact, sometimes it's very hard to figure out what's a religious practice. Take the example I just mentioned, a religious business owner who operates their business in their point of view because of some religious vocation or religious calling. Well, is that business religious? Well, from the owner's point of view, it is. But from the state's point of view, it might just be a for-profit business. One approach to this would be Madison's approach, saying, look, we might not be able to define with precision what a religion is or is not, but we can define clearly whether the state is exercising legitimate functions in terms of what it's doing. Is the state legislating for the general welfare? Look, the state, from Madison's point of view, the state can't legislate on religion. So if a statute or regulation uses religion as a criteria for benefit or not, it's illegitimate. Right? You can identify what the state is supposed to do, and as long as the state stays within its legitimate sphere, it's fine. And so you won't have to figure out if this woman is religious or not, if her business is religious or not, if you're not giving exemptions based on religion. So you just legislate for for-profit companies. And if she's a for-profit company, you can regulate her, as you do other for-profit companies. Right. So I think these practical problems can be gotten around. It doesn't mean, there's certain things that are difficult, but I don't think it's impossible. Please, yeah.
The letters that Jefferson wrote that you gave some excerpts from, one was to Alexander von Humboldt, a German Enlightenment figure and scientist. The other was to someone named Castellos. Is that also European?
I think he was French, if memory serves me right. Yeah.
So my question is, did Jefferson write in a similarly fairly dramatic way or radical way to fellow American?
Yeah, that's a really nice question, and it gets into the problems of interpreting Jefferson, because these letters I quote are not public letters; they're private letters, and it's better. I think in some ways it's better to rely on his public documents. My justification on relying on the letters is that the letters, I think, reveal a commitment or commitments that better explain his practices, which are public. So we know what Jefferson did. How do you explain it? And these letters explain it. But it's really difficult to interpret Jefferson because I just take, did Jefferson believe in God? Some places Jefferson says he's a materialist. Other places he says he believes in God. Maybe he was just inconsistent. Maybe he was saying different things to different people. Maybe you have to interpret the letters in context. And that's difficult. So any interpretation of Jefferson, mine included, is an interpretation and that reasonable people could disagree with. Just to go, when I wrote the book, I thought the stuff I had to say about Jefferson was the most novel and most interesting. And so the advice I got by my mentor was put the chapter on Jefferson in the middle. So people who really want to find it can find it, and people who don't will object to the book being published, maybe they won't get to that part. So I think what I have to say about Jefferson is probably the most controversial thing I said tonight. And lots of scholars would disagree with what I had to, what I've said. But any scholar's position is subject to criticism because it's just hard to know what Jefferson said. Right? If you want to rely on Jefferson's public statements, you turn to his statement, the Virginia Statute of Religious Freedom. But then you have a hard time understanding, well, why did Jefferson do the things he did? All right, what are we to make of that? Okay, how about some students? Please, ma'am. Yeah. We'll do one first and then the other.
The letter. Okay. So based on what you said about the founding fathers, it seems like there should be a lot of people don't know this about founding fathers. They don't know what their opinions were on the separation of church and state. So it seems that a lot of the arguments that I've heard for keeping religion out of government, putting religion into the government, on the basis of the fact that it was intended to be a separation of church and state according to the founding fathers, it could be kind of, I don't know, it seems like there could be a lot of holes in those kind of arguments. What would you say to someone that says, well, the founding fathers want religion out of the government? Like, what would you say to them would kind of be like what would you say to them? Like, would you say,
well, I would say the same thing you would say, which is clearly you need to buy this book, right? That is the one lesson you should all take from tonight's, right? It's, there's a couple things you might say. First of all, this happens in law, of course, because law relies on precedent, and in some ways these founding fathers are used as the sort of the foundations for the precedents. And so there are implicitly appeals to authority. Right, the founding fathers are authority, and there's a role for appeals to authority. But you might just want to say, well, what's the argument? Right? Whatever it is they're advancing. Why is that a good argument? Why is that a good relationship between church and state, or between religion and politics? In some sense, it doesn't really matter who made the argument. Right? The Federalist Number 1 talks about the Constitution being adopted because of reflection and choice. Right? Publius, I think Hamilton in this case, or Madison, I think it's Hamilton, Federalist 1, defends the Constitution because it's defensible, it's a reasonable, it's a good Constitution, which can be supported by arguments. So take whatever founder you want, and it's interesting to us maybe because these arguments are made by the founders, but I think what all three of these founders would say, you should adopt my position not because I am Jefferson or I'm Washington or I'm Madison, but because these arguments are true or good or politically prudent, right? This is, in some ways, I'm known as an originalist scholar. But at the end of the day, even if you're an originalist, that means you try to follow the original meaning of the text. You have to make another argument that this original meaning is worth following. Because if the original meaning's no good, why would you follow it? So I'd say the same thing about your question implicitly raises, I think. Are these good arguments? Is this a good understanding of religious freedom? And too quickly we want to get to an authority, whatever it may be, a founder or some other authority, precedent, and say, well, just because the founder said this, then we should follow it, or just because this precedent says this, we should follow it. There's a reason for those types of legal arguments. But I'm not litigating a case here. We're trying to understand why should we follow this principle or this law? Why should we use this interpretation to implement this law? Right. And so I'd encourage you and to try to get to the arguments. That's what's most important.
Let's take just one more question. Go.
Okay, well, I suggested the the gal next. Yeah.
Okay, well, my question is more geared towards your book and just why you decided to be an expert in this. I mean, what compelled you to do all of this? Was it some background experience personally, or was it something that just really interested you?
Yeah, that's a nice question. That was so long ago, I don't remember. I tell you, it wasn't for the money. That's true. Yeah, so that's a nice question. Thanks for asking that. So there was a case, you might know it, a 1990 Supreme Court case on this Native American, members of a Native American church were ingesting peyote. You know, the Smith case. It's a crazy case, you know. These guys, they're out, they're not even real church members, but they're hanging out with church members and they ingest peyote. And it turns out that they get fired from their job because they test positive for taking drugs. Well, it turns out they work for the state, and what are their jobs? They're drug counselors, right? I mean, you can't make this up, right? And so the case, so they're denied unemployment insurance. So it's not that they were arrested for ingesting peyote. They were fired for testing positive. Then they apply for unemployment compensation, and the state says no. I mean, you're a drug counselor, you tested positive for drugs. I mean, you shouldn't get unemployment compensation because you're stupid. I mean, that's not, right? So they appeal to the Supreme Court. It's an Oregon case. So they win at the Oregon Supreme Court, and it goes all the way to the Supreme Court. Supreme Court says, wait, you got to do this all over again, and could they have been arrested? And then the Oregon Supreme Court says no, and it goes all to the Supreme Court. And the Supreme Court out of nowhere says they could have arrested them, therefore they don't get unemployment insurance. And so I'm reading this case, and I thought, that's an interesting case. And I didn't know what side I agreed with. Right? And so it was interesting to me, personally, because it gets at these questions, I think, get at the very nature of the limits of government, right? We talk about conservatives talk about limited government more than those on the left, but we all actually believe in limited government. There are certain things that the government shouldn't do, right? Because we believe in freedom. Well, everyone would agree that the government shouldn't force us to be religious. Where we all believe in religious freedom, I think, hope. But what does that mean today? And so it's interesting historically, it's interesting philosophically, and it's interesting constitutionally in our politics, right? And so I suppose those intellectual questions and questions of wanting to, because the historians have done such a bad job, not to mention the legal scholars that rely on those histories, and it was interesting to me. I think it's important. I'm an advocate of our Constitution and our constitutional freedoms. So I suppose that's why. Thank you very much.
Thank you all for coming out, but especially thanks to Kyle Volk, who finally got us into some of the technology so we could go ahead with the program tonight. I think Kyle deserves a big hand.